Good morning. Less than 24 hours ago, I addressed you regarding the ongoing industrial action between the Bermuda Industrial Union and Fairmont Hamilton and Fairmont Hamilton Princess that stemmed from an employment dispute. Yesterday, I outlined that my ministry had taken steps to seek both sides and bring them together as part of the arbitration process. Granted, yesterday was a day of high emotion, with both sides seeking to get across their various viewpoints. However, today I am pleased to note that the two sides, with the assistance of government, have managed to come to a resolution which benefits all concerned. The resolution was agreed to and accepted by the B.I.U. and the Fairmont Hamilton Princess management, and I'm happy to note that it is anticipated that all employees, including our public service workers, will return to work later this morning. Well, I will leave the specifics of the agreement for the B.I.U. and the Fairmont to expand upon. I would like to touch on the efforts of our government representatives who worked hard to bring this situation to a close. I'd like to thank the Attorney General Mark Pettingill and his staff, and the Permanent Secretary of Home Affairs, Mr. Randy Rochester, and the Director of Workforce Development, George Outerbridge, for their work around the clock to get the two sides to the table. And I wish also to thank the Green family for recognizing the importance of working with us to bring this matter to a close for the good of Bermuda. Without question, this government recognizes the inconvenience that this situation caused the members of the public and to our visitors. So we appreciate their patience and understanding during which was obviously a challenging time which saw them directly affected by the disruption of services. If anything, these past few days have demonstrated the importance of maintaining strong relationships between employers and unions, the importance of following the guidelines as set out in the collective bargaining agreements, and the importance of going through the right channels of mediation to find resolution. As I indicated yesterday, the government will always recognize the rights of the workers. However, when disputes arise, we must be ever mindful that the labor process works best when it is rooted in a collaborative effort. I'm happy to take a few questions.
I'm going to start on this end with Tarai.
Yes, good morning, Minister.
Good morning.
Can you confirm if the 10 workers have been reinstated at Fairmont?
Again, the specifics of what has been agreed between the Fairmont and the B.I.U. I think should be best left for them to comment upon. That is the agreement that they have come to. It's up to them to share that information.
In light of this entire situation and the B.I.U.'s zero tolerance for perceived breaches of employment matters or employment breaches in general, will government be more sympathetic to the union's cause going forward? Will it change the way government will handle these sorts of situations?
I don't think there would be any change, and I'll say this. As I said yesterday, there are collective bargaining agreements in place. It is certainly been recognized, I think, by all parties that it's important to follow the terms of those collective bargaining agreements and to follow the terms of the Employment Act, which in fact makes it clear that there should be a collaborative effort between parties prior to redundancies. I think that's part one. So people have their grievance, and they're entitled to take the right steps under the collective bargaining agreements in that regard. In relation to any further action that comes as a result of these breaches of collective bargaining agreements, as I said yesterday, there are very specific routes that should be followed to come to resolution. That's under the Labor Relations Act, and if necessary under the Labor Disputes Act. That has very specific things that must be done to bring things to a resolution. We were fortunate that an agreement was reached today, and certain steps did not then need to be looked at further in terms of following those procedures under the Labor Relations Act and the Labor Disputes Act. So I'm not sure if that's answering your question, because I think that things were handled in the way that they should have been handled in respect of how government has dealt with things very effectively.
Minister, actually, you answered my question yesterday. You answered it today, so thank you very much for that.
Thank you.
We just came from a rather revival type press conference at the B.I.U. where they appeared to feel that they are the winners. The winners and losers in both these things. But what I'd like to know, what lessons can be drawn from this situation where we've almost gone to the precipice?
I don't think there's any winners or losers in any of these things. I think what's important is that the parties talk and collaborate. And that's one thing that we've been trying to do over the past year, is bring employer groups together, bring union representatives together through the Labor Advisory Council, which I think has been quite effective. Parties build trust that way. I think when things happen that shouldn't have happened, of course the temperature rises very quickly. And we saw some of that yesterday. What I will say, and I will repeat this very clearly, and I will continue to repeat it, I think it's very important that parties follow the respective bargaining agreements. That's why they are there. Bargaining agreements are there. All parties have agreed. It's the very nature of the collective bargaining agreement. If there are disputes that arise under those agreements, there is dispute and grievance procedure to follow. And I think that is where we as government and the Director of Workforce Development, under the various acts, steps in if disputes are reported. The government acts when a dispute is reported. If a dispute is reported under the Labor Relations Act, the Director of Workforce Development makes his inquiries and tries to make and come to a resolution and conciliation. Again, if that cannot be reached, it's my role as Minister of Labor, or Minister responsible for labor, to step in and make the appropriate reference. And then we start appointing arbitrators and tribunals as appropriate into the circumstances. With any of these things, again, like I said, it's important to follow the right process and procedure. Whilst all of that process and procedure is going on, it's important that the parties continue to dialogue. And I suspect that's part of what was missing in some of what happened between the Fairmont and the B.I.U. yesterday. That it escalates to a point, perhaps because there should have been more dialogue between those parties. And that is what then the ministry does, is gets involved to try and facilitate that. And I think because of that facilitation, it certainly helped in getting a resolution today, to get those parties talking. That's what's important. And then we can, then the temperature lowers and the tone reduces. So whether we got the precipice or not, I don't know if we reached that point. I think what we got to was a point where there was disagreement that led to further action. But I think through collaboration, continuous dialogue, that can be lowered.
Jonathan, did you have any questions at all for the minister?
I imagine what a lot of people would be wondering, if these types of disputes arise in the future, is there any way of preventing it from affecting buses and transport? That was the main thing on people's minds yesterday. I think a lot of folks sympathized with the union cause, but they were greatly inconvenienced. And is there any move beyond encouraging dialogue to prevent the services themselves from being affected?
Someone said to me recently that you can't legislate for bad behavior. And you can't. If parties desire to go outside the bounds of the law in respect of following the various acts, there's not a lot that can be done save for going through the proper procedure as appropriate. There are, for those that are unaware, there's certain sections under the essential services part of the Labor Relations Act that list out those services that are essential services. Transportation services is not currently listed in the schedule of what's termed essential services. It just simply is not. It falls under any other labor dispute procedure in relation under the Labor Relations Act. So that is something that has been considered, and we will continue to consider and work with our partners as to whether they should be added. Having said that, if you add something and the procedure is still not followed, then we as government have to continue to follow our procedure, and that is to appoint arbitration tribunals and go down that road. It's not as simple as simply saying to any party, you haven't followed what we want. That's not how the process works. Process is clear. If there's a dispute, you can't come to resolution, you appoint a tribunal as appropriate, the parties continue to dialogue and appoint their respective individuals to those panels. It's not a quick process. It's unfortunate, but that is why dialogue and collaboration is most important, so you never get to the stage of having to implement the procedures under the various acts. So what I would urge all parties going forward, that's government, that's unions, and that's employer groups, to continue that dialogue and work through issues when they arise, and not simply say, well, I'm not going to participate in a process. And that's not to say that anyone did that this time. I'm just saying generally that parties should follow the procedures and dialogue wherever it is absolutely possible.
Yes. Minister, when could we see employment tied into concessions? I know you touched on it briefly.
from the outset when these redundancies
Mm.
came about, but where are you really going with that one?
No, that's a great question. I would say that when the Concession Act was put into place a number of years ago, I don't think anyone at that time had envisaged in any way that what would happen in some circumstances that there would be redundancies. So I think that that needs to be considered, and it is being considered. It has been raised with government. I have also raised it with my colleagues, and we'll look at that. So, I mean, I can't preempt what may or may not come. I'm saying that it is something that's now being actively looked at to say, should we be saying, okay, you get concessions, but you also have to retain employment during that period of time of concession? And I think it's absolutely right to look at that. It's something that was obviously not foreseen by anyone. And obviously those two things have been linked in respect of this particular issue that happened over the last couple of days. And I don't think that's an unfair thing to say either, by the way. Certainly I had raised it in addition to a number of other individuals about whether that's fair. I personally think it's probably not fair. But that's something that we have to address.
Yeah, you mentioned the collective bargaining process, and there's been a lot of talk of this consultation provision,
Mhm.
this collective bargaining agreement. Any indication of what that provision specifically entails, number one, and number two, was that provision broached, in your opinion, in this instance?
Right. What I will talk is in general terms. Again, I'm not going to comment as to whether one party breached the agreement or not. I won't do that. What I will say is that in most collective bargaining agreements, and most agreements like that, there are provisions, one for grievance procedure, but also talks about redundancy. And normally the process is, if it's not explicit, it's custom and practice, that when redundancies are likely to be made, there is a consultation that takes place between the employer and the trade union. That's also explicit in Section 34 of the Employment Act of 2000. That makes it clear that there should be consultation. Now, parties can debate ad nauseum, what does consultation mean? What I can say is that the Labor Advisory Council last year agreed that under certain acts there should be certain periods of time when we talk about consultation. And that was presented and agreed by Cabinet, and has been agreed at the Labor Advisory Council as to time limits in terms of what does consultation mean. That's not specific to collective bargaining agreements, but it is specific in relation to a number of the labor relation type acts that talks about periods of time of consultation. So what I say in relation to that is I urge the parties to contact their respective employer groups, etc., and read that document.
Just a quick follow-up. Mr. Ferber just made some comments suggesting that recently public employees, specifically employees of the Parks Department and Marine and Ports, have come very close to striking in recent months. Do you have any reaction to those comments?
I was advised of there to be some issues in relation to those departments by the President of the Bermuda Industrial Union this morning. We're looking into what those grievances may or may not be. But at this stage, I have no further comment on that.